I think the one concern that I have, and that's been raised, is that you may have, again, pharmacists who are in a certain area, and the manufacturer says, this is the price I'm charging you, and the pharmacist has very little leeway in order to go above that amount. So the pharmacist will then defend, saying, hey, I'm not the one who determined this would be the price. This is something which the manufacturer imposed on me. And my concern is that when the Attorney General goes and does his action, oftentimes in a lawsuit, you'll try and name as many parties as possible. You're going to name the manufacturer, but you could also then have named an innocent pharmacist as well. And the bill does allow the saying that there is a rebuttable defense that with evidence that the costs were not within the control of the defendant and they were imposed on the defendant for the drug subject to the storage. So the pharmacist could say, I had nothing to do with the price. The manufacturer gave it to me at this amount, and that's where it's raised. My problem is the pharmacist may have to go through many months and years of very costly litigation before they get to that point. I'm concerned they could be, unwillingly harmed in this bill.
Yeah, I understand where you're going with it. I just don't believe. I think the language of this bill clearly states that before an action can be commenced, if you look at lines 30 to 35, makes it very clear that the Attorney General, in consultation with the Department of Health, has to look at all of the pricing dynamics within that supply chain before an action could even be commenced, where you would find exactly where the gouging took place and whether or not a pharmacist had any role. I think in this chamber we have been very careful to protect the viability of our independent pharmacies, play a key role in our communities. I certainly, and I don't think any of the co-sponsors of the bill would want to put them in any greater risk, other than to say that in the very limited instances where the FDA lists a drug in short supply, and if you look at the categories of drugs that are usually listed, many of them are injectable drugs that are needed by cancer patients and other life-saving medications that manufacturers oftentimes will either discontinue. There's a number of reasons why they might end up on short supply. All of those dynamics would have to be considered before a case could even be commenced. I don't think the Attorney General has the time or the staff to waste his energies, nor would any of us want to see independent pharmacies bear the brunt of legislation aimed at protecting patients in the end, mostly, but also our Medicaid and Medicare dollars from being overspent on what we believe are great market vendors who inject themselves in this supply chain and take advantage of those conditions to mark up the prices.
And so you would say, for example, there's a news story this past year of a pharmaceutical CEO, I think it was Turing Pharmaceuticals. There was a drug which dealt with the AIDS epidemic, and what it was dealing with, they decided to raise the price by 5,500% to $750 a pill just because he could. Is that the type of situation you're really trying to address?
I would hope so, except that I don't know if that particular drug was listed as short supply by the FDA.
Right.
I would love this bill to include all medications. We are trying to approach this in a very conservative way to say that drugs listed as short supply, where you can see these dynamics playing out. There are reports in the language, you can see it in the memo, that allude to instances where prices have been marked up 1,000 or more times its normal price, and that's the unconscionable sort of price raising that we want to address and make sure that the Attorney General can go after. And if it's the manufacturer, I actually don't believe it's a manufacturer as much as great market vendors, independent parties that, again, seek to take advantage of these conditions to make a dollar at the expense of our systems, our taxpayer dollars, and the lives of New Yorkers who need these life-saving medications.
Okay, thank you.
Thank you.
Ms. Gunther? Read the last section.
This act shall take effect immediately.
The clerk will record the vote.
Are there any other votes? Announce the results.
Ayes 110, noes 4.
The bill is passed. Mr. Morelli.
Yes, thank you, Mr. Speaker. If I could give the next 4 bills I'd like to take up in this order, if I might. I'd like to go immediately to calendar number 258 on page 19 by Mr. Buchwald. Follow that with calendar number 422 on page 33 by Ms. Simon. Then take up calendar number 8 on page 4 by Ms. Paulin. And in this group of bills, I'd like to finish, in just this group of bills, I'd like to finish calendar number 100 on page 9 by Mr. Zabrowski.
Clerk will read.
Assembly 6944, calendar 258, Mr. Buchwald, an act to amend the executive law.
An explanation is requested, Mr. Buchwald.
Thank you, Mr. Speaker. This bill is brought forward on behalf of the New York State Division of Human Rights to bring New York state law in compliance with the Federal Fair Housing Act.
Mr. Goodell.
Thank you, Mr. Speaker. Would the sponsor yield?
Will you yield, Mr. Buchwald?
Yes, Mr. Speaker.
Good. Before you start, members, we are reminded that we are now on debate. We'd like to hear the debaters. Any conversations that must be had, you can have them in the rear of the chambers and not around the rostrum and not on the floor. Thank you. Proceed, sir.
Thank you, Mr. Speaker, and thank you, Mr. Buchwald. As I understand it, under current law, if someone believes they're a victim of housing discrimination, they have an initial choice. They can bring an action in court, or they can bring an administrative proceeding, file administrative proceeding in the Division of Human Rights, correct?
That's what our bill memo says, so you are indeed correct.
And if they are unsuccessful, either in court or in the Division of Human Rights, they have the right to file an appeal and have someone else review the results, correct?
That's correct.
So what your bill does is says, if I understand correctly, that if you go with the Division of Human Rights and you lose, in fact, they find there's no probable cause for finding a discrimination, you would then be able to go back to court as though you never went to the Division of Human Rights? Is that right?
That's right. And our own Division of Human Rights has put forward this bill because they want New Yorkers to have the full set of rights that are guaranteed to them under federal law.
Well, as you know, and there are a number of different evidentiary standards that we deal with in court all the time. We have beyond a reasonable doubt, which is a very, very high standard, right? We have clear and convincing evidence. That's the next level, very high standard. We have preponderance of evidence. That's what applies in most civil cases. Probably the lowest evidentiary standard is probable cause, because all probable cause means is that there's some reasonable grounds to believe you might be right, not even a preponderance of the evidence, but some reasonable grounds. Why then, if the Division of Human Rights has determined there's not even a reasonable ground to believe that there is a housing discrimination, why should you be allowed to begin a new lawsuit?
Well, Mr. Goodell, to the extent that an attorney was advising a client who believed there was housing discrimination, would that attorney be well advised to potentially give their client advice that taking their case to court after they've been denied at the Division of Human Rights itself, whether that would be wise or prudent or a good way to spend resources? Perhaps not. But nonetheless, the housing discrimination rules in this country provide that everyone shall have an opportunity to be heard in court. We like the fact that here in New York State, we have a Division of Human Rights that provides people a mechanism for having their case heard separate from using the full court system. We think that that works quite well. We want to preserve the people's rights to do that. if we do not bring New York State law, though, in compliance with the Federal Fair Housing Act, then the federal government could decide to take away New York State's right to have a Division of Human Rights oversee the enforcement of federal housing law. And I myself would rather the New York State Division of Human Rights provide services to New Yorkers than to rely on HUD and other federal agencies.
As you know, in other contexts, for example, medical malpractice, you can bring an action before a medical malpractice panel, and if you don't like that result, you can bring your action in court. So that's what you're suggesting is not unprecedented. But in that context, in the context of a med malpractice action, the result of that panel analysis is admissible in the subsequent court proceeding. Am I correct? There's nothing in your bill that precludes the admissibility of a finding of no probable cause in the subsequent court proceeding?
Well, certainly the court proceeding is allowed to come to its own conclusions. The person who brings the housing discrimination complaint would be entitled to a de novo review in court, meaning that the court's allowed to look at things with fresh eyes. They're not certainly bound to what the Division of Human Rights has said. But, you know, hopefully our Division of Human Rights and our courts end up in general being on the same page. But in any case, we would be able to see with passage of this bill over time whether there is a disjuncture. If there is, people are entitled to have their day in court.
My question, though, is really very specific. Can the landlord, in a subsequent court proceeding, present into evidence the fact that the Division of Human Rights found no probable cause whatsoever for housing discrimination?
Well, I guess all questions of evidence are up to the court system. I would say as a general matter, a finding that's occurred after the fact doesn't necessarily shed light on whether housing discrimination occurred in the underlying facts, but ultimately it's up to a court to determine what's admissible in their court of law.
Am I correct that under the current administrative proceeding, a person who believes they're the victim of housing discrimination would have a full and fair opportunity to present their case in front of the administrative tribunal?
I believe they would. That's certainly our hope, and it's also the hope of the Division of Human Rights that supports this bill.
And if they have a full and fair opportunity to present whatever evidence they want and to make whatever arguments they want to make, doesn't the finding by the Division of Human Rights then have collateral estoppel effect in a subsequent court action or result in issue preclusion?
Not under this legislation, because there would be an entitlement to essentially de novo review. So,
well, you have an entitlement to go to court, but that doesn't deal with any of the judicial remedies of issue preclusion or collateral estoppel, does it? There's no language in your bill dealing with collateral estoppel, is there?
Nothing explicitly, and in any case, Mr. Yell, if your point is that by bringing New York State into compliance with federal law, we might not actually be significantly modifying the housing discrimination laws of the state, I certainly agree with that. All that we're doing with this bill is providing rules for how complaints can be heard, not the underlying substance of housing discrimination law.
Thank you, Mr. Buchwald. On the bill?
On the bill, Mr. Goodell.
This is an interesting piece of legislation because it says that you can go in front of the Division of Human Rights, a state agency or local agency, whose sole function is to make sure there's no violation of human rights. That's what their function is. And you go in front of the Division of Human Rights, who's solely focused on making sure there's no violation of human rights, and they listen to your case, and you have a full and fair opportunity to present your case. You have an opportunity to present every evidentiary piece of information you have, and at the end of that, if the Human Rights Division concludes that you did not even establish probable cause, you didn't even establish a reasonable belief for discrimination, This bill would give you the right to start all over in court. Now, the problem is these proceedings cost people money. They cost landlords money. They cost everybody money. And they cost time. And they create disruption. And they clog our court system. So under the current system, if you present your case and you don't like the result, you can appeal it. If for some reason they made a mistake, you can appeal it and you can get a judicial review. This allows you to start all over so nothing happened. It's a colossal waste of time and money. But even more serious, if there's no probable cause for your housing discrimination and you've had a full and fair opportunity to present your claim, when you go to court, guess what the first motion is? These claims have already been heard. And so under well-accepted judicial precedent, dealing with what we call collateral estoppel or issue preclusion, these issues have already been heard. You can't relitigate the same issue over and over and over and hope that maybe at some point you'll find someone that might agree with you. You got to present your best case and right at the beginning and then live with it or appeal it. It also, by the way, opens a false door for people who are claiming housing discrimination. It's a false door because our current court rules provide that if you bring a lawsuit and you don't have a reasonable grounds to believe that the facts of the law can support you, if you don't have a reasonable ground, you face the potential of sanctions. It's Rule 130, which unfortunately you can't look up on this because we don't have the regs at your desk, but it's Rule 130, and it says if you don't have a reasonable ground to believe that the law or the facts will support your case, you can be forced to pay the other side's attorney's fees or costs. So when you walk into court with a determination that you have no probable cause for your claim, you're setting yourself up for liability in the subsequent case. The current system we have allows a person to make the claim right from the beginning. I want to go to court, or I want to go to the Division of Human Rights. They have the full and fair opportunity to present their case. If they don't like the results, they can file an appeal. We shouldn't offer a way that ignores that whole process, will not change the result, and sets up the person for a potential claim for frivolous sanctions. I don't think this bill is necessary or appropriate, and I don't think it's the right way for us to go as a state. For these reasons, I would recommend my colleagues vote against this bill. Thank you, Mr. Speaker, and thank you, sponsor, for your comments. I do believe it may be constitutional, however.
Thank you, Mr. Goodell. Read the last section.
This act shall take effect on the 90th day.
Clerk will record the vote. Mr. Buchwald to explain his vote.
Speaker. Mr. Speaker, were we not to pass this bill and enact it into law, at some point it is possible that the Federal Department of Housing and Urban Development could decide that New York State won't be allowed to hear housing discrimination claims. And I might say that some folks would be concerned with ceding to the federal government that entire issue, especially since every once in a while I hear complaints about the Department of Housing and Urban Development's approach when it comes to housing discrimination. Suffice this to say, New York State should be in compliance with federal law. We should make sure our Division of Human Rights is empowered to hear these cases. And if the cost of that is the potential, although I don't think great potential for duplicative actions, so be it. I think that folks will know that if they've already heard their case, and that they don't need to bring it necessarily to court a second time. But this bill gives them that right because federal law gives them that right. And New York State should be upholding our ability to enforce housing discrimination law. So therefore, I'll be voting in the affirmative, and I urge my colleagues to. Thank you, Mr. Speaker.
Mr. Buckwald in the affirmative. Ms. Simon to explain her vote.
Thank you, Mr. Speaker. I would just like to indicate my strong support for this bill. It is well-settled law in the Second Circuit that an enforcement agency, a federal enforcement agency, if there is a finding of no probable cause, that is no bar to bringing an action in court, and that is Supreme Court law as well. And this would just codify that and apply that to the citizens of the state of New York, because something could change at the federal level, but clearly this just gives people more protection. The administrative agencies very often issue findings of no probable cause without actually even speaking to the complainant or doing any investigation. So I think it's quite important that we pass this bill, and I just wanted to indicate my support, and I'll be voting in the affirmative.
Ms. Simon in the affirmative. Are there any other votes? Announce the results.
Ayes 89, noes 29.
The bill is passed.
Assembly 8566A, Calendar 422, Ms. Simon, an act to amend the public health law.
An explanation is requested, Ms. Simon.
Yes, the purpose of this bill is to create a procedure for the closure of privately funded assisted living facilities.
Mr. McKevitt.
Sure, will the sponsor yield for a few questions?
Will you yield, Ms. Simon?
Certainly.
Sponsor yields.
If we can just walk through a couple of sections of the bill, I just want to just clarify some of the provisions on it. On page 1, lines 14 through 17, the way I read it is that before the private assisted living facility must go and close, they must have the department approve, I guess, a closure plan in order for that to occur. And the bill, do you actually have any time frames? I know it cannot be any sooner than 120 days. But as an outset date, with the department is backlogged, could it take a year or 2 years before the facility is actually able to close? How would that actually procedurally occur?
This does not have an outside time frame within which the State Department of Health would have to make that decision. That is currently the case. It may be that they negotiate various aspects of closure with the entity that is seeking to close the facility. And they can go back and forth for quite some time. That's part of their current process, and that is not changed by this bill.
Actually, it brings me to another point. Actually, in page 2 of the bill, on lines 25 and 26, you state that as part of the final approval of the closure plan, the department operator shall agree on a target closure date. What if they are unable to agree to that target closure date? You know, the facility may say, we need 5 months. The Department of Health says it's a year. Can that go infinitum, try and just agree upon a date before they can come down with the closure plan?
It could, and it could currently. This doesn't change that.
Okay. Just, again, another concern with the bill is when you look at, again, page 2 on lines 28, 29, 30, it talks about when providing the notification of the target closure date to the residents, the operator shall notify residents that additional time will be provided to residents who make good faith efforts to secure an alternative setting and demonstrate a reasonable basis for needing more than 120 days to transfer to the alternative setting. How is the facility supposed to determine whether a person is making a good faith basis or not making a good faith basis? It seems like there may be some subjectivity in that.
Well, there may be, but currently the residents have no rights whatsoever with regard to that. This is born out of a particular situation that has occurred in Brooklyn,
Right.
which has very few assisted living facilities, where the landlord just decided to kick out a lot of 90-year-olds and 100-year-olds and left them with really no options. There's significant litigation around this issue, and right now there are no established procedures to protect the residents of such facilities, their families, or in some cases, this is a protection for the facility if it is truly engaging with its residents to provide alternative locations for them if a closure is indeed necessary.
And I understand certainly the intent. I mean, you have a facility where people are really dependent upon for living. You know, again, you're mostly dealing with elderly people who need, you know, some sort of assistance for their day-to-day needs. You certainly want to make sure that doesn't close in a very quick period and they're unable to provide for it. But again, just a couple other just drafty questions I have. You know, when you talk about the fact that, yes, you want to go and allow residents a good faith ability to try to find another facility, which I think is certainly a good idea. But when you look at lines 11 and 12, again on page 2, the operator shall not close the residence until all residents of the resident have transferred to appropriate alternative settings. And my concern is, yes, you want to make sure you protect both the facility as well as those living there, but you may just have a resident who just doesn't want to move somewhere else. And they say, I'm going to stay here longer. So even though in one part of the bill, you talk about residents who have a good faith basis for buying a new home, but for those who choose not to have a good faith basis and say, I'm just going to stay here for a while because I so choose to, it doesn't seem like it gives the facility the ability to come to a date by saying, okay, it's enough time, because again, according to the bill, they can't close until all residents have found a new place to live.
Well, I think you're conflating a few things here. I think it's important to recognize that that they can't just empty the facility when people do not have the right kinds of places to go. That they have to actually work with the residents to help them find a place to live that is appropriate to their needs and is a safe place and a place that, in terms of location and their family needs, et cetera, will be found for them. And the nursing home or the assisted living facility is often in a better position to help engage in that with the resident than the resident is themselves or the resident's family is. So this is an entity that is in possession of more facts and more resources than the average resident that is now should be taking a positive and constructive approach to working with people to find them alternative locations if that's what is necessary. The reality is that this provision about good faith gives the entity, if someone is not acting in good faith or just simply refusing to leave, and they are the last one and they have done nothing or their family has done nothing to try and find an alternative location, that certainly would seem to be an argument that the facility could make.
But that's my point. If you have a person who's not acting in good faith and they're not moving on, and the bill says they cannot leave until the residence has transferred to another facility, what is the facility supposed to do?
Well, I leave that to the wisdom of the facilities and their abilities and the Department of Health to perhaps work with them to resolve those issues. I'm quite sure that were such a situation to arise, there would be a resolution of that situation.
And certainly you made the point that I agree in most instances the facility will have the financial resources and a much better bargaining position to help people find a new location and a new place to go. But let's say you have a situation where for whatever reason the facility was in economic distress and they just no longer had the ability to keep the place open, and you had one or a handful of people just staying in the facility because they choose not to go elsewhere, then what's supposed to happen? If the facility has no money, then what occurs?
The facility will have to avail itself of possible resources and work that out with the Department of Health.